I'm pleased to greet all the participants in this webinar about law and religion at the time of coronavirus. Let me extend a warm welcome to all our guests. And I will immediately give the floor to Professor Pierluigi Consorti, who coordinates our project of research. Thank you, Pierluigi.
Thank you, everybody, and good morning. I want to share with you the possibility to have a little time to reflect together on these important questions that we have nowadays. As we all well know, we are experiencing one of the most difficult health emergencies since World War II. The new coronavirus is the cause of a new and not yet well identified disease called by an acronym Covid-19, which to date has caused more than 9 million victims all over the world in 6 months. The Johns Hopkins Coronavirus Center yesterday counted 400,672,856 deaths, and the pandemic, which in Europe seems, at least in part, under control, continues to grow progressively in many other parts of the world. While we await the answer of our fellow scientists who study viruses and seek a vaccine, we, as law and religion scholars, have begun to study social behavior. On March the 8th, 2020, we opened a website and started to collect data and news. And in May 2020, some weeks ago, we published an ebook freely downloadable on the law and religion COVID-19 emergency. Now, we are studying the data to prepare a deeper reflection, but we can already try to give some initial information that we hope relevant for our academic community. The first is the battle against the virus is fought with a very ancient weapon, that of social distancing. At the moment, this is the most effective remedy. We are adopting it as men and women of our time, but in the end, it is the same as we find described in the sacred texts. And this is partly also a problem, given that some religious fundamentalists still seem to have an unscientific and very fideistic approach. There are religious men who declare, now you can go forward, Daniela, because I have already, go forward. I have already said these things. Okay. We stay here. There are religious men who declare that the virus does not infect places of worship, and it is not transmitted through religious rites. That is a transversal objection, which nevertheless seems to me prevalent in Christian narratives, even Catholic ones. There is, I can say, a populist approach which denies the existence of the virus and tends towards a conspiracy justification. It seems to me that there is a civil religion which denies the usefulness of scientific remedies and is more concerned about economic damage than about people's health. We cannot forget that a deeply rooted narrative throughout medieval Christian Europe understood the epidemic as a divine punishment, from which it was possible to escape only with prayers and devotional rites. The challenge posed by the deadly bubonic plague in the mid-14th century triggered a search for the source of the calamity. Europe's Jews were a handy and suspicious target. Pogroms against Jewish spread around Europe, and Jews were bludgeoned and burned to death. In August 1527, the bubonic plague had come to Wittenberg, Germany. Everyone who could get out of the village was getting out. The cause of the disease and its mode of transmission was not known, but the conventional wisdom was clear: stay away from the sick. The Elector of Saxony, John the Steadfast, ordered Martin Luther to leave. He refused and wrote a letter entitled "Whether One May Flee from a Deadly Plague." In this letter, he explained the importance of caring for our neighbor and suggesting the community to take the necessary steps to protect others. Luther defended public health measures such as quarantines and seeking medical attention when available. Those in ministry, I think this is very important also to understand our moment, those in ministry, he wrote, must remain steadfast before the peril of death. The sick and dying need a good shepherd who will strengthen and comfort them and administer the sacraments, lest they be denied the Eucharist before their passing. Public officials, including mayors and judges, are to stay and maintain civic order. Public servants, including city-sponsored physicians and police officers, must continue their professional duties. Even parents and guardians have vocational duties toward their children. But Luther does not encourage his readers to expose themselves recklessly to danger. His letter constantly straddles two competing goods: honoring the sanctity of one's own life and honoring the sanctity of those in need. That is the background that we find in the current German constitutional jurisprudence, as Testa Bappenein will tell us shortly. It is very interesting to note, on the other hand, how rabbinic authorities have updated their ancient tradition related to epidemic. They have written that the sword is hitting the entire surface of the planet, and for believers, it represents a message to humanity to wake up and move towards an internal renewal that cannot be postponed. The current pandemic poses a question of meaning, as it challenged the man to question his ability to fight an unknown and invisible enemy, counting only on rational or scientific forces. Rabbis linked the observance of religious precepts to the rigorous application of state regulations. Indeed, respect for the latter is itself a religious obligation, as the orthopraxis of Judaism translates precisely into the observance of the mitzvot, and the law represents its ontological essence, as recalled by the Talmudic saying of Solomon, Dina de Malkuta Dina, the law of the kingdom is law, and God commands, now choose life so that you and your children may live. Therefore, compliance with all, even in the most problematic circumstances, is combined with the irrepressible obligation to protect one's own health and that of others by every means. the right of Pesach 5780 were subsequently adapted to the pandemic. And similar accommodations involved Ramadan 1441 and more generally all other religions' feasts. And I love to remember here Pope Francis' witness, especially his solitary prayer celebrated in the deserted St. Peter's Square when he cried out on behalf of humanity the intervention of God. So, in few words, religious was not absent. Religious freedom was not absent. Actually, it is still present. During this pandemic, religion is present. We, as DiReSom group, are going to study 3 focus points. The first concern is related to the relationships between law, religion, and emergency rules. The emergency creates a state of exception that produces new laws, rules, and behaviors that are determined by the need to react quickly, which should be characterized by temporariness. And this is not an appropriate attitude for producing rules that will last in an indeterminate time. So, what about religious law according to emergencies when this emergency is not clear? I want to say it's not clear the time of this emergency. The second issue involves a more specific aspect of religious rules, which by their nature seem to be not modifiable by human will. Many religious rules are based on God's will and therefore appear substantially unmodifiable. However, the fight against coronavirus has produced changes previously unthinkable. Therefore, the emergency appears as a source of religious law. And it is possible to imagine a state of exception for religious laws. Daniela Tarantino will give us a Catholic perspective focusing on the reconciliation sacrament. Finally, the third question concerns the quality of this emergency, which is unhealth related and therefore different from other emergencies that may also produce legal modification or rules of exception, such as wars or natural disasters. And I think that in this time, we experienced the force of the dialogue between religious leaders, between religious communities, between religious groups and civil authorities. In this webinar, we want to give you some information about our work. Testa Bapenain and Adelaide Madera, I thank her a lot for the hospitality, will give a glance on 2 courts approach, and we will focus on a specific point that, in my opinion, is very, very important. That is, as I have already mentioned, the dialogue as the important tool to manage emergency issues related to law. There is an interreligious dialogue stricto sensu, as a new kind of institutional dialogue between states and the religious community, or better, states and spiritual representatives. We can share a French and an Italian model. The latter is particularly interesting as it is a real novelty for Italian law and religion policies. And we, as DiReSom Group, are proud to have been able to facilitate with our academic work this path of institutional dialogue, as will be clarified shortly by Professor Giacco. I thank you all for your presence, also if it is a virtual presence in our webinar. And I want to thank EuARe for its hospitality and for the work that it always is doing for increasing religious issues in the academic community. And now I think that is the moment to go forward in our webinar, and I pray Professor Giacco to have his intervention on the dialogue between states and religious groups.
Thank you, Professor Consorti. And I begin with the last words that you have said, because first of all, I would like to thank the European Academy of Religion for the opportunity to discuss about the topics of a research in which we are involved since the beginning of the COVID-19 emergency. And also I want to thank all the colleagues that are connected with us in this webinar. I've seen Professor Angelo Licastro, but perhaps there are others. The title of my paper is The Dialogue Among States and Religious Groups, and I'll talk about this theme in 3 steps, and then I'll try to imagine the method. First step, the dialogue is a secular method in the European Union. Second step, the experience of the Italian protocols for the resumption of the religious celebrations. Third step, the dialogue is a method for the relationships among religions. And the conclusion, the dialogue as a method for the future after COVID-19 emergency. First step, in Italy, during the pandemic, we were saying that after the COVID-19, nothing will be the same. There was the common idea that our way of life will change and that we need to learn the lesson of the pandemic. When the government decided to limit the freedom of movement of the citizens, to stop the increasing of the disease, also the freedom of the public cult was limited. In this first phase, the so-called phase of lockdown, the government didn't ask the religious authorities' advice, and there was no dialogue. The necessity to preserve the public health prevailed over the necessity of the dialogue. Some scholars said that this approach was incoherent with the Italian tradition of bilateral relationships. Other European governments have had a different approach. In France, President Macron has joined together in a video call the religious leaders and the representatives of secular organizations to explain them the restrictive measures that France was going to introduce and to ask their social help. In my opinion, this approach is coherent with the Treaty on the Functioning of the European Union, Article 17, number 3, where we can read that recognizing their identity and their specific contribution, the Union shall maintain an open, transparent, and regular dialogue with these churches and organizations. The transparent and regular dialogue with the religions and the non-theistic organizations is therefore the method chosen by the secular Europe. Second step. The second step is the experience of the Italian protocols for the religious celebrations. The DiReSom research group have played an important role in the realization of the protocols. When the Italian Prime Minister announced the beginning of the so-called Phase 2 and the gradual assumption of the economic and social activities, the churches and the freedom of public cult, they seemed to be forgotten by the government. The DiReSom research group published then a position paper for a safe resumption of religious celebrations in Italy. And the paper was the ground for a meeting, a video conference, with the Ministry of Internal Affairs, the leaders of 16 different religious groups, and 2 professors with the role of mediators. One of them is the Professor Pierluigi Consorti. After the meeting, in few days, there was the signature of the protocols. It is important to underline the method that has conducted the parts to sign the protocols. It is important, this method, because this method is the method of the dialogue, the transparent and inclusive dialogue of the Article 16 of the Treaty of European Union. I think that this is a secular method. It's not the fruit of a negotiation, but it is a text open to the adhesions of other religious communities, if they want to adhere. We can say that the pandemic caused an evolution in the Italian state-churches relationships, until now blocked in the hierarchic bilateral model. The third step, the dialogue among religions. During the pandemics, the Catholic Pontifical Academy for Life published a document with the title Pandemic and Universal Brotherhood. In it, we read the reflection on the meaning of freedoms and rights. The first ones, during the emergency, turned out to be intertwined and overlapped for better and for worse. But also the rights are interdependent, and there is no right that does not have a resultant correspondent duty. The pandemic has clearly showed this interdependence, but, the document notes, the interdependence does not automatically turn into solidarity. This occurs also in the relationships among the states that can't confront the pandemic by reasoning in terms of exclusive defense of the national interest, since a global threat requires global responses. An emergency like that of COVID-19 is overcome with, above all, the antibodies of solidarity. In the same days, the Higher Committee for Human Fraternity, an interreligious organization born after the Abu Dhabi Declaration, proposed a day of prayer, fasting and charity in order that the world will be freed from the pandemic, becoming more fraternal. The day was celebrated on 14th May 2020, and it was obviously a religious celebration. But it was also an event with a political meaning. Pope Francis, in the homily of the morning Mass of May 14th, said that the coronavirus pandemic is not the only pandemic that affects the world, since there are others such as the hunger pandemic or the war pandemic. According to the Pope, only thanks to fraternity, humanity will be able to overcome the pandemics. During the pandemic, religions reminded politics of the value of fraternity, the revolutionary principle that underlies modern democracy, which must be the basis to go beyond emergency and to plan the future. Conclusion. The World Health Organization launched a program called Solidarity. This program is an international clinical trial to help find an effective treatment for COVID-19. As we can read in the internet homepage of the organization, the Solidarity trial will compare 4 treatment options against standard of care to assess their relative effectiveness against COVID-19. By enrolling patients in multiple countries, the Solidarity trial aims to rapidly discover whether any of the drugs slow disease progression or improve survival. In my opinion, the use of the word solidarity as the slogan of the program is not accidental. Solidarity, or fraternity, seems to be the answer in post-COVID pandemic. We have seen the role that solidarity played in state-religious relationships as a secular method, and the importance of fraternity in interreligious relationships. Dialogue and solidarity of fraternity is the method for the future. This is, and I conclude with these words, the third focus point of the research, as Professor Consorti said at the beginning of our today meeting. And I think that we have to work all together to find a new model, a new way of relationship between state, religions, and states after COVID-19 pandemics. Thank you for your attention.
Thank you, Professor Giacco. I think that it's very interesting to follow this webinar, because I can understand that we can go deeper in our reflections that we started only some weeks ago, and we was all in quarantine in our houses, and was the first impact. And now we are going to go deeper. And I think that this reflection about the, I can say, plural pandemic that Pope Francis gave us, and you remember us today, is very interesting. And also the, I can say, the link with solidarity and in your approach or fraternity is very interesting also to understand how religious law can go forward to understand and to give answers that we need to have. Now I pray Professor Ivaldi that will give us the perspective of the dialogue and cooperation between French institutions and religious groups. In these weeks, Professor Ivaldi follows very well the French situation. So you have the floor. Thank you.
Thank you, all you. It needed some preliminary remarks about French secularism to understand better the specific of French approach in this period. The law 9 December 1905 instituted and defined the state separation from the churches, excluding the founding of religion by public institution. This secularism from the 1946 Constitution has assumed the specific form of French laïcité. It's a system which appears to be characterized on the one hand by the affirmation of the principle of strict neutrality of public institutions, and on the other hand by the recognition of religious freedom of individuals, which over time encounters limits, especially in terms of external expression. Furthermore, there are no spatial relations between the state and the different religious institutions. French law does not define what religion is or what secularity consists of. Reference should therefore be made to the different laws and the interpretations by case law. The doctrine identifies a certain evolution of secularism, albeit always in maintaining a strict separation between what is relevant for the state and what is relevant for religions. Among the most recent sensitive issues that have arisen are the wearing of religious symbol at school or at work, and the admissibility of wearing the full veil in public space. The SARS-CoV-2 pandemic in France, as elsewhere, have been characterized by the enactment of emergency regulation, often discussed from the point of view of constitutional compliance. Throughout the pandemic, important powers attributed to the governor and ministries outside effective parliamentary control. Powers that affect the exercise of important fundamental rights such as freedom of movement, assembly, or religion freedom. The freedom of religion has been from the beginning one of the key issues of this period from several points of view, also in the spread of the outbreak, as confirmed by the annual meeting of one evangelical megachurch, the Christian Open Door Church in Mulhouse, eastern France, between 17 and 24 February. The most important cluster in the diffusion of coronavirus across metropolitan France as well as its overseas territories. This is not the context for a detailed analysis of the very numerous series of measures that have followed since the beginning of the epidemic. However, the government decrees that marked the main phases of the period must be mentioned. We have a phase of total lockdown, a phase 1 of lockdown lifting, and we are now in the second phase of lockdown lifting for the interference with the religion freedom. The first phase of lockdown is characterized by the decree 23 March number 293 that started with several lockdown imposing several closure, schools, business, facilities, but not places of worship. In other words, only essential services like food shop, pharmacy can be open, like also public services like hospitals. This decree also enacts restriction as the banning of all non-sexual movement and contact with people outside the home. There is a mandatory home confinement, including others non-cohabiting family members and relatives. Citizens was asked to avoid gatherings of more than 10 people in public space. Limits are also placed on the movement of individuals, only 1 kilometer from their home, except those relating to professional activity, buying essential goods, health or family reasons of brief individual exercise. This circumstance which confine the chains for believers to go to the various places of worship for individual prayer. All religious gatherings are forbidden. Only one exception is provided for funeral ceremonies, allowing groups up to a maximum of 20 people, including the celebrant and the funeral home staff. In any case, it should be noted that many religious groups, has provided, even before the lockdown, for self-limitation, or in any case, had ordered the total closure of the place of worship in compliance with the respect for human life as a priority, also over the exercise of religious freedom. This was the case with the Jewish, Muslim, and Buddhist, who first announced the suspension of prayers and then the shutting of temples, mosques, and synagogues and pagodas. Conversely, many churches, especially Catholic churches, remain open throughout the lockdown. The suspended in-person worship during the COVID-19 pandemic has conducted religions to lead virtual services and prayer that was broadcast on traditional media, radio and TV, and on the new social one like YouTube and Facebook, to maintain a bond with believers during the temporary moratorium on public worship. The prohibition on public worship has raised and still raises some important doctrinal issues for the different religious groups, especially for those whose rights are not considered as admitted in the virtual form. This is the case, to give just one example, of the Orthodox Jews who are forbidden to use electricity during Shabbat or other festivities, and consequently to use television and computers. The measures taken at this stage, and this can also be said for those which will follow, are of course adopted unilaterally by the state institution. Nevertheless, the President of the Republic, Emmanuel Macron, in his different speeches to the nation, has always called the French to unity and national cohesion. This is the spirit that inspired the first meeting, scheduled by video conference on 23 March by the President himself, with representatives of cults and other philosophical perspectives, including Masonic organization and atheistic and agnostic one. This is a meeting that will be followed by another, one less than a month later, on 21 April. And the third one that President Macron predicts will be held in the future to address the post-pandemic. This meeting represents a communication channel to the highest level through which President Macron anticipates the government health crisis measure to the participants. In the same way, this meeting allows to understand the instances of the different stakeholders, taking into account the collaboration that they can offer both spiritually and materially. Not all cults, and in the French legal system the word cult has no disrespectful value, are invited, but only those that can be ascribed to the Conférence des Responsables de Culte en France, Conference of Worship Leaders in France, created in 2010, namely Catholics, Protestant, Orthodox, Jewish, Muslim, and Buddhist. To these representatives in the second meetings will be added the evangelicals, probably both for their relevance in terms of members and for the reason that they have blamelessly started one of the most important clusters in the country at Mulhouse. In addition to general issues, specific questions were also addressed concerning the establishment of free phone numbers for psychological and spiritual assistance by the different religion, or specific items concerning in particular the treatment of mortal remains and burials. Issues that subject to a further dialogue with the Interior Ministry in charge of cults or local government responsible for cemetery. Emmanuel Macron has guaranteed that who die in France during the coronavirus outbreak will be buried in accordance with their religion beliefs and tradition, excluding any mandatory cremation, a practice forbidden in Hebraism and Islam. Also, the treatment of the deceased according to religious prescription remains with certain limits, even if in compliance with the health prescription foreseen in order to avoid contagion. A specific problem has been posed by the French Muslim Worship Council regarding the lack of adequate space in the Islamic areas of cemeteries, taking into account the fact that the pandemic has precluded burials in the countries of origin, a very common practice among Muslims, but also present in Hebraism. An issue which has been the subject of a specific discussion between this council and the Interior Ministry, with the involvement of the local authorities in charge of this matter. The most interesting phase is the phase 1 of lockdown lifting. During the second meeting, the 21 April, President Macron foresees a first restoration of public worship by mid-June at the earliest. Similarly, the Prime Minister, on the occasion of presentation to the Parliament of the plan for progressive lockdown lifting, announces the reopening of school and many commercial activities, but not the possible celebration of religious ceremonies. With the notable exception of the Catholic Church of the religion referred to in the above-mentioned conference, really accept the situation. All of them constantly guided by the need to give the highest priority to protection of life. Then the decree 11 May 2020 is issued despite the remark made by the French Episcopate, but the decision on this point made by the Council of State at the request of some private individuals, traditional Catholics association and the political party confront the governments with the urgent need to review its position and re-establish the exercise of collective religious freedom. The government complies with Decree 22 May, allowing the immediate resumption of religious celebration. At the same time, the Interior Ministry acknowledged the constant dialogue between French institutions and cults, announced that although it's possible immediately, it is recommended that resumption of public worship take place only starting from June. Only the Catholic Church will take advantage of the immediate resumption of religious gathering, while the other faith communities will do so progressively thereafter. For example, Jews, Muslims, and Buddhists will respect the government recommendation by reopening after June. Only one thing about the phase 2 or lockdown lifting covered by Decree 31 May, because this decree, in force of this decree, the celebration of civil marriage and also same-sex ones or pacts civil de solidarité, suspending during the pandemic, except in the case of danger of death and similar cases, can restart. This is an important circumstance given that French law only allows for the validity of civil marriage, which must necessarily be celebrated before the religious one. There are also a prescription of criminal codes in force. What about the end of lockdown? The government project to formally declare the end of the lockdown with a project now on discussion in Parliament. For the moment, the third appointment of the French President Macron with the representative of the cult, Freemasonry and Humanistic or Artistic Association is not yet fixed. Despite the many criticisms Macron faced, to whom the breach of certain uncompromising declination on French laicité was attributed, the practice introduced seemed appreciable even if compared to that provided for the yet recalled Article 17 of the Treaty on Functioning of the European Union. In the meantime, religions have not stopped questioning and confronting each other about the epochal challenges emerging during the outbreak, as happening during the meeting held just yesterday evening at the Collège de Bernardin. Collège de Bernardin, where just the 9 April of 2 years ago, President Macron, invited by the French Episcopal Conference and in the presence of representatives of other religions, had the opportunity to decline his vision of secularism, which does not have the function of denying the spiritual. Thank you for the question.
Thank you, Maria Cristina. Thank you. You advised us that you need 5 minutes more, and you had these 5 minutes more. So thank you for your report. It's very interesting. I don't know now, Adelaide, if we want to give the floor for our attendant for 5 minutes. If there are questions to the two presenters that have already finished their presentation, or you want to prefer to go forward and then collect at the end?
I guess we had better to go on and then leave some space at the end of the webinar.
Okay.
As you like.
No, okay. I want to remember that we would like to finish at 1 o'clock, so we have some minutes more. And if anybody want to have remarks or questions, okay, they could also use the chat that we can collect them, and at the end give the opportunity to give some answer or extend our reflection. And now is the moment of our guest, Professor Madera, that will give us some remarks on the United States Supreme Court and religion and law in this COVID period. Thank you, Adelaide.
Thank you to you, Pierluigi, for your introduction. I will speak about a specific aspect because I will focus on a recent decision of the Supreme Court, of the US Supreme Court, which declined to enjoin enforcement of the restrictions concerning religious gatherings. But first of all, I would like to give a brief framework. So there are some, I guess, 3 important points I should underline. First of all, in the USA, due to the COVID emergency, a legal fragmentation had been exacerbated. So we had different situations in different states, because in some states religious exemption had been provided, in other not. So in some states the ban of religious gatherings gave rise to fierce litigation in front of courts. So we have this different situation between states, where in some states religious activities has been qualified as essential activities. In other states, it had been completely parified to secular activities, and so considered as non-essential activities. So this is the first point I would like to underline. The second point, as I said before, is that these prohibitions, these bannings of religious gatherings gave rise to fierce litigation in front of courts. So we have many decisions. We had many decisions. And the crucial point, the crucial issue is which is the correct judicial standard that has to be used in this specific situation. In this specific situation, when the problem is the balance between a pandemic, so a health crisis, and on the other side, on the other hand, the exercise of religious freedom. We had some old Supreme Court decisions. We have some old Supreme Court decisions, but I have to say that they are not connected with a pandemic. They are connected with the protection of health, the preservation of health as a collective interest that finds protection under the constitutional test. Under the constitutional test, I mean. The third point I would like to underline is that in this specific situation, we have many statements coming from the Department of Justice. This implies a strong political intervention in the present situation. So we can speak about law COVID in the age of COVID, law religion in the age of COVID-19, but we have to speak also about law religion and the coronavirus in the age of Trump. So in this complex framework, I would like to give my understanding, my own understanding of this decision of the Supreme Court. So taking into consideration that this unparalleled health crisis resulted in several United States the intervention of the Department of Justice. And the problem is if federal intervention can facilitate the reconciliation of the competing interests, or whether it risks increasing the current tension, which is about the role of religion, whether religion deserves a special protection, whether we have to speak once again about exceptionalism of religious protection in the USA, on if USA are losing such exceptionalism in the protection of religious freedom. We have to think about academics who wrote essays saying why we have to tolerate religious freedom. So now I go to speak about this case. It is within this controversial framework, that the Supreme Court had to face the critical question, whether and to what degree executive powers are allowed to restrict fundamental liberties which are grounded in the constitutional text. Second question, which is the secular comparator? If we have to compare religious activities to secular activities, which is the correct comparator? Because this is a really bright difference. So we have to take into consideration that we are in the phase 2 in the USA On May 22, 2020, President Trump announced that all states must immediately lift the restrictions on places of worship. So on May 25, Governor Newsom in California issued the new safety guidelines concerning also places of worship and providers of religious services. And these new guidelines specified how and when a place of worship can reopen in California. So there is a harsh reaction of a church because the new guidelines specified specific limited attendance at houses of worship to 25% of building capacity and a maximum of 100 attendees. So plaintiffs, a church, asked injunctive relief against the order, so as to be permitted to hold worship services during the Pentecost Sunday. They obviously, by virtue of their commitment to adhere to the neutral social distancing requirements that apply in the county of San Diego. So we have a sharp division between judges. The judges were split over whether public health measures can justify exemptions in the name of religious freedom. So we can see a highly polarized US Supreme Court. Even though the hold rationale, the Jacobson rationale, remained the cornerstone governing the balance between the safeguard of public health and the protection of fundamental liberties. So I have to explain the only opinion. It is not a majority opinion because we have a 5-2 division of the judge, but only one judge wrote the opinion of the court. So it is the Chief Justice that wrote the opinion of the court, and so the Chief Justice seemed to find a sort of balance between his conservative nature, but also his spirit of institutional respect of the precedent of the test cases. So the Jacobson rationale remained the cornerstone governing the balance. According to the Chief Justice's opinion, their restrictions are consistent with the free exercise clause, as similar restrictions apply to comparable secular activities, where large groups of people gather in close proximity for extended periods of time. So he put a distinction between comparable secular activities, which are those ones where large groups of people gather in close proximity for extended periods of time. And there is a different treatment from exemptions that have been provided for dissimilar activities which concern those places in which people neither congregate in large groups nor remain in close proximity for extended periods of time. For example, when you go to shopping, when you go out. So Roberts joined the liberal wing and declared the prevalence of the interest to the safety and the health of the people. So according to Roberts, and I quote his specific words, the precise question of when restrictions on particular social activities should be lifted during the pandemic is a dynamic and fact-intensive matter subject to reasonable disagreement. So, second question, who are the bodies who are charged with the difficult task of finding a solution? According to Roberts, the solution is entrusted to the politically accountable officials of the states. What does it mean? This means broad powers to executive powers in this sort of situation, this kind of situation, when those officials undertake to act in areas fraught with medical and scientific uncertainties, their freedom of action must be especially broad. And so there is another important sentence where Roberts faces the interrelationship between the judiciary and the, political democratical processes. He says, where those broad limits are not exceeded, they should not be subject to second guessing by an unelected federal judiciary, which lacks background, competence, and expertise to assess public health and is not accountable to the people. So for this reason, they claim that state measures are unconstitutional, according to the Roberts opinion, seems improbable. So this decision confirmed obviously the judgment of the Court of Appeals. I cannot speak about that now. I would like only to underline the important dissenting opinion of Judge Daniel P. Collins. And then we go on to the dissenting opinion. So Justice Kavanaugh complained Roberts' opinion. He spoke about a narrative of invidious religious discrimination. So according to Kavanaugh, the claimant suffered the imposition of a worse treatment in comparison with other secular activities because of its religious status. So we can come back to the Camera decision. Discrimination against religion that recently had been grounded in the Supreme Court decisions on the free exercise clause. So the church would suffer irreparable harm from not being able to hold services on Pentecost Day in a way that is comparable to secular business and persons that can conduct their activities. So Kavanaugh invoked that the state of California had to show the existence of a compelling interest and a compelling justification for distinguishing between religious worship services and other secular business. So, as you can understand, the Supreme Court intervention gave rise to a fierce debate between the first commentators. The judges are split on a crucial question, which is the role of the judiciary, namely whether the current health crisis requires a differential attitudes towards a representative of the people's will, or whether it justifies a more interventionist role of the judiciary. In this specific moment, this is not only a legal question, it is also a question that has deep political implications, taking into consideration the specific political situation, the specific presidential policies, and the politically divisive character of religious freedom in this specific moment in the USA. So the issue is about the special nature of religion that is at the center of an increasing debate. So which are the, the sharp critics that this decision gave rise. Some commentators claim that the court is inclined to protect new rights, such as gay rights, abortion rights, and at the same time, it adopts a self-restraint attitude when a well-established basic freedom is at stake. And the Chief Justice had been accused of false judicial modesty. And they also, commentators also raised the concerns on whether such executive government powers are in contradiction with the Bill of Rights and the incorporation jurisprudence by which the Supreme Court case has been applied to the states. However, the Roberts opinion underlined the possibility for government officials to impose a rule of conduct to the people who elected them during a health crisis, excluding second guessing by an unelected federal judiciary. And this decision, as I said before, shows again a highly polarized court when the Chief Justice is playing the role of the ideological center of the court and often maintains the deciding vote. Two brief remarks. Taking into consideration this decision, we have to say that we have 4 conservative judges that would have liked to make use of the court powers to undermine public policies. The main difference between the two wings of the court revolves around their identification of the most appropriate secular comparator. So the judges wonder if religious activities are more similar, for example, to grocery stores or to concerts where a large group of people gather. And so, according to Roberts, religious gatherings require stricter rules than certain secular activities as shopping, banking, and so on, because of the way they are conducted. Staying in close proximity, longer times, singing and speaking at worship services, which increases the danger for people. During a severe health crisis, a basic freedom can be subject to severe restriction, where its accommodation is not reasonable. I mean, in this case, there was not a complete ban of religious services. So the claim is not about a ban of religious services. The claim is about some cautionary measures that went not to restrict the exercise of religious freedom, but only to give some guidelines in order to exercise a religious freedom. I spoke about about the division within the court, the secular comparator, and the last but not least, further concerns are about whether this decision may have an impact on future addresses of the lower courts. And in this case, I have to underline that we have no majority opinion. The nature of the judgment, because we have a request for a major agency injunctive relief. So in this case, it was not an opinion. I mean, Roberts was not compelled to write his opinion. His decision to write his opinion has also a political meaning. When I wrote the pendulum swung too far, he would like to reestablish the rule of the test case, the precedent. At the same time, he tries to avoid that the Supreme Court is involved in a sort of political conundrum. So where the issue of religion becomes a politically divisive matter. At the same time, I said, no majority opinion, the nature of the judgment, the difference concerning restrictive measures from state to state. So not an uniform solution in all the USA, but a fragmentary situation, and the absence of a clear explanation between about the distinction among different activities. So it means a law being for lower courts. It cannot be underestimated that during the same days there was another request to the Supreme Court, and in this case the Supreme Court issued a similar order for injunctive relief, but without giving this broad opinion. So I will stop because I say I would like to underline again that the reason for this opinion is what the nature of the judgment. The nature of the judgment did not require an opinion, but Roberts tried to reconcile the competing interest in order to prevent the highest judicial board being dragged into a political conundrum, losing its credibility. Okay, thank you very much for your attention.
Thank you, Adelaide. And I want to give you the possibility to have this intervention to Professor Testa-Pappenheim that drive us again in Europe in a German perspective. Thank you, Professor Testa-Pappenheim.
Thank you, Professor Consorti. Thank you, everybody. Also, the proliferation of the proliferation and spreading of the COVID-19 epidemic has meant that even in various European states, and not only in Italy, gatherings of people have been prohibited with the issuing of specific rules, which have also included community religious celebrations. This has resulted in a certain friction in various countries with the relative constitutional provisions for the protection of religious freedom. The emergency rules issued in the various states have already been the subject of the ANPI. The objection of unconstitutionality for violation of religious freedom was raised in Spain before the Tribunal Constitucional, in France before the Conseil d'État, and in Italy at the Lazio TAR, while in Germany the issue has already come before the Bundesverfassungsgericht 3 times on the basis of case developed before the administrative jurisdictions. This shows how it is a problem common to countries that are very distinct and distant according to the Habermasian articulation of three well-known paradigmata. On the one hand, the absolute secularism French model, at the extreme opposing the open-minded one, Italian and Hispanic model for various historical reasons, and in the middle, the neutralist one, German style. This system presents a particularly complex constitutional framework for the protection of fundamental rights, conditioned partly by the emergent situation, foreseen by the constitutional rules, and partly by the principle of Verhältnismäßigkeit, elaborated by the constitutional jurisprudence itself. As is now, the German Grundgesetz contains in the preamble an explicit reference to God, which is moreover deeply rooted in the German cultural historical milieu and the European one in general. On the basis of the Gesetz zur Verhütung und Bekämpfung von Infektionskrankheiten by Menschen, the states can order restrictions and limitations also on constitutionally recognized fundamental rights, the implementation of which is then entrusted to the various Länder that act with their own regulations. The intervention of the Amtsgericht of Altenburg in Thuringia was requested by a Lutheran minister of worship who wished to go to give spiritual assistance to his own parishioner, hospitalized with fever. It involved an 89-year-old woman. As a pastor with care of souls, having spiritual talks with her. Thuringian regulatory provisions to combat coronavirus, however, have sealed the place of treatment, preventing access even to ministers of worship, even if they were willing to comply with all the necessary health precautions to prevent contagion. The court, questioned by the pastor, proved him rights on the assumption that his visits were not of a personal nature, but, says the sentence, constituted to exercise of a truly central element in the heart of the mission of a minister of worship, particularly in times of epidemic, according to the example given by Martin Luther himself on the occasion of a bubonic plague epidemic in Wittenberg in 1527. The aforementioned federal law on the health emergency explicitly provides that in case of quarantine, the minister of worship engaged in the care of others must absolutely always be admitted, in compliance with all the safety procedures, to visit the sick person, Article 30, paragraph 4, while other persons, for example, a psychologist, relatives, friends, etc., may be accepted at the discretion of the attending physician. The judge observed that the care of the souls constitutes the heart of the duty of churches. For this reason, the norm does not foresee any limitation that can be imposed on the minister of worship, to whom an absolute right is recognized, reflecting the right of religious freedom foreseen by Article 4 of the Grundgesetz. A society of Berlin apostolic life of pontifical rights, linked to the celebration with the extraordinary rite, presented an administrative appeal against die Verordnung über erforderliche Maßnahmen zur Eindämmung der Ausbreitung des neuartigen Coronavirus of Berlin, which, in the context of the containment measures of COVID-19, while expressly allowing individual visits to place of worship, had at the same time prohibited religious celebration open to the public, outdoors or indoors, as a harbinger of potentially dangerous gatherings. For the Berlin-Brandenburg OVG, the limitation measure is not preordinate in order to compress religious freedom, but this compression is the indirect result of very general measures aimed at limiting the spread of the coronavirus. In this measure, in compliance with Article 2, paragraph 2 of the basis of the Grundgesetz, that is the protection of life and physical integrity, which are also constitutional rights that could not have been achieved otherwise. The right to religious freedom, the court states, has not been harmed because there was not intention of it, because place of worship have always remained open to all of people to enter to pray, and finally, because it is possible, and indeed it seems that religious communities have made extensive use of the streaming transmission of religious services. If, therefore, religious celebration continued to be celebrated and seen by the faithful, and the latter continue to be able to go to their buildings of worship for individual prayer, taking into account the emergency situation, we can say that the restrictive measures did not affect the substance of religious freedom, but rather its method of organization, which undoubtedly underwent such a further disarticulation, totally limited in scope and duration. Partially adopted by the Verwaltungsgerichtshof of Bavaria, where the law provides for the general prohibition of meetings and assemblies, explicitly declared also applicable to churches, mosques, synagogues, and places of worship of other religious denominations, except for exception granted by the competent civil authorities. A Roman Catholic believer brought a dispute claiming his religious freedom pursuant to Article 4 days at the 107 Bayerische Verfassung, contesting both the general prohibition, which the applicant claimed was unjustified because the community religious function could have been organized with health checks and reservation by telephone or application, and against the absence of an exception admissible on the basis of the legislation itself. In his opinion, the ban on attending Sunday Mass was a violation of religious freedom, but that of attending Masses on Easter solemnities constituted a double violation. The appeal was dismissed for lack of active legitimacy et petitum. As all 27 German dioceses have taken autonomous protection measures against the epidemic, including, in almost all, the suspension of the precept of Sunday Mass and, in general, of all community religious celebrations. In addition, the Archdiocese of München and Freising has already suspended all community religious celebrations on 3rd March and until 3 April, that is, before the disputed provision, and on 2 April with a general decree pursuant to Canon 29 CIC, immediately in force pursuant to Canon 8, paragraph 2 CIC, had extended this suspension until 19 April, that is until after Easter. As was probably foreseeable, the matter went as far as the Bundesverfassungsgericht, before which it was raised several times. First, the judge of Karlsruhe were asked for an emergency measure to annul the sentence of 7 April of the Verwaltungsgericht of Hesse relating to Section 1, Paragraph 5 of the Vierte Verordnung über Kämpfe, etc. The applicant, as we already seen, declaring that he is a practicing Catholic, complained that the Vierte Verordnung made it impossible for him to attend Mass and particular religious rites specific for Holy Week, and considered the limitations imposed on the exercise of their fundamental rights of religious freedom pursuant to Article 4 of the Grundgesetz, and therefore unconstitutional. The Bundesverfassungsgericht rejected the application, recognizing it admissible but refuting its merits, because if it accepted and then reopened it for the celebration of community masses, but more generally for community religious function of any confession, it would cause an enormous increase in the risk of infection, which already reported certain consequences of an overload of the national health system, including the extreme risk of its collapse. Moreover, the court considered the limitation proportionate pursuant to Section 2 the Grundgesetz, given that it is temporary and limited to a set deadline. Thank you for your attention.
Thank you, Professor Bappenheim, for your remarks. And now I think that is the moment to go on with Daniela Tarantino. Is she with us? Yes, she is here. That will speak about the resilience of reconciliation to Catholic Church. Please, Daniela.
Good morning. Thank you for this important opportunity, and I apologize for my little English. I go into the merits of my topic. In the current pandemic state, in which participation in liturgies and sacraments is severely limited, the Catholic Church has worked to find ways and times to answer to the COVID-19 emergency, and following the sign of the times, has adapted the forms of exercise of the Munera Ecclesiae, first of all the Munus Sanctificandi, in order to push the Salus Animarum, as a function of which the law of the Church is constantly renewed in order to respond to the needs of the faithful, reproposing the demands of an ongoing sociality now wounded by the pandemic. In this context, the sacrament of confession is of central importance, as it highlights the inseparable link between the formal and the substantive aspects of law, particularly in a legal system that has flexibility tools capable of applying the equitas as a means of updating it. The present circumstances made the sacrament of reconciliation even more necessary, stimulating the Church to recover ancient and exceptional forms of administration and at the same time to develop new ones. This is the case of the dry confession, an idea born in a city in Maryland in the United States, where Father Scott Holmer, a priest of the Catholic Church of St. Edward the Confessor in the city of Bowie, began to confess the faithful in the church parking lot through the car windows of the penitents, in order to stem the spread of coronavirus. From the United States, the idea spread to Europe, arriving first in Poland and then in France. In Warsaw, in the weeks preceding Easter, the priest Mateusz Kielarski of the Temple of Divine Providence, one of the largest churches in the city, decided to administer the confession of the faithful in the parking lot of the building of worship. These from the cockpit of their car can also listen to the liturgical music played by employees, and leaning out of the window, they can confess and receive absolution from their sins. Also in Poland, Father Adam Polonski, parish priest of Rogalin in the Poznan region, decided to offer his parishioners the opportunity to go to confession before Easter without getting out of the car, administering the sacrament through the lower window of the interior of his car, and putting his vehicle at prescribed distance of at least 1.5 meters. From Poland, the dry confession landed on April 25 in France, in Limoges, where Father David de l'Estapi, parish priest of St. John Paul II Church, and his vicar Father Vincent Poitot, respecting the health rules, confessed the faithful for about 2 hours in the parish car park, positioning themselves under a mountain for the occasion, under which they stopped with the engine off in front to specially prepared cages, without therefore having to move from their car interior. On-the-road confession is certainly an apprehended method of administering the sacrament, which, however, takes place in the presence of the penitent and confessor. Unlike the method suggested by Reinaldo Narn, Peruvian bishop of the prelature of Caravelí, who authorized priests to make confessions by telephone, emphasizing on confession as medicine of the soul, and therefore on the confessor as medicus animarum, as well as iudex peccatorum, underlining that in the church the salus animarum must always prevail. And in Bergamo, one of the Italian cities most affected by COVID-19, the priest Luciano Locatelli administers the sacrament of reconciliation through WhatsApp, in the belief that Jesus at the time would have done the same thing. I don't care, said the priest, who wants the sacrament to get right, but I share it with those who believe in the power of forgiveness to build a humanity that is worth of the name. From a certain perspective, the use of current technological tools appears impraticable given the absolute inviolability of the confessional seal, Think of a video call or the presence of another person next to the penitent. On the other hand, the violation of the seal does not operate due to the mere presence, certainly morality regrettable, of audio or video material hidden by the penitent or by a third person during the confession in order to record it, but only in the case of spreading or disclosure of matter object of the sacrament. Even the auricular confession made in places traditional, assigned to its administration, doesn't always protect against the violation of the seal, whose absolute inviolability can be granted by the awareness of both the confessor and the penitent of the sacredness of the act, which doesn't depend on the place where it happens, neither by the way it takes place. In this historical moment, when distance appears to be only tool capable of curbing the spread of contagion, the virtual embrace given by the word of comfort of a priest can represent for the faithful relief from the affliction, the way of the soul. In particular, precisely with reference to modalities of administration of the confession, the Church should manifest herself not only as an institution, but also as freedom of the spirit. Moreover, during the pandemic, the use of modern technologies has supported the diffusion of sacramental grace on several occasions, and it seems appropriate that priests should also be able to carry out their function as medicus animarum using, where possible, these tools without placing obstacles formal. This may be an additional opportunity for this crisis to become an opportunity to look at what is truly essential for our lives. Thank you very much for your attention.
Okay, here we are. Sorry for my attention. I can give the floor to Luigi Guzzo. Thank you for his intervention.
Thank you, Professor Consorti. I want to thank also the European Academy of Religion for this opportunity. And I start with my presentation. So do you see my presentation? The slides?
Yeah.
Yes, we see.
I want to talk about the interreligious dialogue as the dialogue between religion and between religions. And I think that one of the most iconic photos about interreligious dialogue in COVID-19 time was published by CNN on March 2020. A Jewish paramedic prays facing Jerusalem, while a Muslim paramedic prays facing Mecca before him. It is an individual level of action, but however, I think it is a representative image on how interreligious dialogue is a tool to face coronavirus emergency, both institutional and individual level. In fact, the coronavirus pandemic has crossed the national borders, regardless religion or culture of people. It inspired the moments of interreligious unity, connecting believers and also non-believers across religions. Interreligious dialogue as a tool to face coronavirus emergency is a consequence of the impact of this pandemic on religions. It is an impact so strong that even Wikipedia has made a page about it. Interreligious dialogue is very important, and we can say also that now in the University of the Pope, the Latin University, started this year the first course in interconfessional theology. First of all, it is necessary to define interreligious dialogue. According to the World Council of Churches, there is a difference between ecumenical, interfaith, and interreligious dialogue. Ecumenical means relations between Christian denominations. Interfaith means relations between Abrahamic faiths, such as Christian, Jewish, and Muslim traditions. Interreligious means relations between different religions, such as Muslim, Buddhism, or Hinduism. Caldwell distinguishes between interfaith as a political concept of the public square and interreligious relations as an understanding of how the Church engages with the religious other, both in terms of actual dialogue and also Christian self-understanding in its encounter with religious plurality. These are Christian perspectives, internal point of views by a religious tradition perspective. But it is not easy to find a legal definition of interreligious dialogue globally and interreligious accepted. But maybe it is not necessary, because it is however clear that interreligious dialogue has a geopolitical role as a peace-building function. This geopolitical impact is well synthesized in the Yang-Kung formula. No peace among the nations without peace among the religions. No peace among the religions without dialogue among religions. According to Paolo Naso, the geopolitical role of interreligious dialogue find an icon in the Assisi meeting of October 27, 1986, wanted by Pope John Paul II. In this geopolitical dimension, we could take a basic definition of interreligious dialogue as a positive cooperation between people of different traditions at both the individual and institutional levels. To include atheists, agnostics, humanists, and others that is ethical or philosophical beliefs, as well as to be more accurate concerning many world religions that are different from our Western religions, some scholars prefer to use the terms interbelief dialogue or interpath dialogue. According to some scholars, I don't know, like Moltmann, interreligious dialogue is different from the dialogue between believers and non-believers. But the dialogue between believers and non-believers is also very important in our age. According to the legal philosopher Leonard Dworkin in his book Religion Without God. To face coronavirus emergency, interreligious dialogue takes different forms. 3 forms. 1. Interreligious dialogue as a moment for praying together. The meeting organized by Religions for Peace on 30 March in which certain religious leaders held a virtual interfaith moment for hope and solidarity. We can talk also about the meeting of the leaders of the three Abrahamic religions, Christians, Jews, and Muslims, held in Jerusalem on 26 March amid the global coronavirus COVID-19 pandemic. And also we can talk about the Interreligious Day for prayer organized by the Higher Committee for Human Fraternity to pray to free humanity from the coronavirus pandemic, and this meeting was based on the principle of the human brotherhood of the Declaration of Abu Dhabi, as Professor Giacco said also in this conference. The second form is interreligious dialogue as a practical action inspired by solidarity. And we can talk about the case of Pakistan, where Muslim volunteers entered in mosques, churches, and Sikh temples to disinfect the places of worship, and then distributed food and other necessities to Muslim and non-Muslims. The third form is an interreligious dialogue as a way, as a base, we can also say, of an effective protection of religious freedom in a pluralistic society, such as in Italy or in France, the experience of sanitary of the protocols. So, thanks to the interreligious dialogue, was inaugurated new seasons in the relationships between the religions and the state. During the COVID-19 emergency, interreligious dialogue is favored because the global reply of religious organizations to the coronavirus pandemic has a similar regulatory scheme. Similar are in fact the sanitary and the safety measures during the celebrations, and the number of people during them. The suspension of the collective meetings, the cancellation of big events, and in most cases the closure of the places of worship or the denial of access for the worshippers. Of course, we have to deal with this kind of perspective, taking into consideration that the self-accepting degree of the religious rules can be different in each religious context. But the Catholic religious authorities suspend the Sunday Mass just like the Islamic ones suspend the Friday prayers, and so the Protestant with their cult. The Mormons close their temples, and so the Jews. Ludus bats close, and so the Baptist places of worship. The spread of the measures is similar, via websites or official pages on Facebook or Twitter or on YouTube. And this occurs around the world. This occurs in all the religions. It is interesting to underline that there is some cross-religion and cross-cultural idea of salus. Salus is a Latin term that can be used for indicating the health of the body and the health of the spirit. The different forms of interreligious dialogue assume a same idea of the health of the body, It is true also in a moral perspective. All the religions, for example, consider that the virus is the evil. So there is a common idea of the life in the earth, and all the new emergency religious laws, the sanitary emergency religious laws, have a fourth characteristic in common. All the provisions are made more or less formally on the basis of the political measures. That means that the religion's independence and autonomy from the political communities is find a recognition. So there are issues such as the human safety on which the religions don't have authority. So far, nothing new. The modernity probably starts from here. But it is new that this time religions have clearly admitted this principle. Religions know that they don't have a political authority about human safety. Religions know what means human safety and agree in the meaning of a human safety. And this is because they are, however, important actors to cooperate with the states to face pandemic. So, coronavirus, I think, reconciles everything, even the religions. Thank you for your attention.
Okay, thank you all. Now we have 10 minutes. If somebody want to have some remarks or questions to our speakers, or somebody want to intervene, it is possible to switch on microphone. So, it is not necessary to do it. And I think that if nobody wants to intervene or to say anything, I can thank you all for your attending here. And I think that we were able to demonstrate that now we are at our, I can say probably at our phase 2, and that we have to go deeper to study this connection between law and religion, religions and state law, and also to the emergency. We hope that we are going out of the full emergency. Also, if the situation all over the world is not so simple, and invite all us to pay attention, probably more attention, and probably also to pay attention at having solutions and I can say reflections that can give us the opportunity to not remain in an emergency. I think that the emergency is, according to the law, is possible only if we have a temporary possibility to stay in this. So let me greet also our colleague that I cannot with at the beginning of our reunion, particularly Professor Lee Castro, Professor Franceschi, I have already done, I saw that were also Professor Marta Tigano, and there were also Professor Otadui from Spain, and I hope that I do not forget anybody, nobody. And let me thank again Professor Madera, and I ask if she can give some conclusive remarks too, or to greet everybody. And from my side, I thank you again.
I would like to thank you again, Pierluigi, for giving all of us the opportunity to participate in this extremely challenging project. And I would like to thank all of those who attended the meeting. I guess it was a really interesting and challenging conversation when different points of you had the opportunity to interact. So it was really interesting for all of us. And thank you again to everybody, to all the participants. I would like to extend my greetings to the students and also to the professors of other universities that attended the meeting. Thank you again for your attention, everybody.